Welcome back, everybody. I'm really excited to do this part two with you guys. So many of you guys know, I'm a police trainer and instructor. I train and instruct military and law enforcement on various law enforcement disciplines to include constitutional law, case law, patrol tactics, investigations, etc. And so a lot of you guys, and most of you guys, understood the implications of Pennsylvania v. Mimms, but as we're going through this, I'm realizing there's a small minority of you guys that seem to think that there is some kind of conspiracy behind Pennsylvania v. Mimms, and that somehow it requires reasonable articulable suspicion that somebody's armed and dangerous before they can be removed from the vehicle. And so there seems to be these concerns. And so what I want to do now is just make a video on Pennsylvania v. Mimms myths and kind of flush this out in a more academic and common sense standpoint. And again, and let me be very clear, I need to be honest with my biases straight up. And so that's what I'm going to do at the very beginning of this video, because I realize I have biases. And so I'm going to admit what those biases are, I'm going to explain what they are and why, and then, we'll go forward with the video, because I think that's important, because I truly believe in transparency, and I truly believe in openness. And I think that's something we have to realize. Like, I am not trying to trick anybody or hide anything. I think the best way forward, because we know there's a problem within law enforcement circles, right? We know that there's certain issues. I think training is one of those big issues. So instead of me trying to be, hush hush and secret about it, the best way to make sure our law enforcement are smarter is to make sure the citizens are smarter. Because where do police officers come from? They come from the citizens, right? So in order to be a police officer, you have to be a citizen first. And so what better way to get that training than through citizens? This is the same way through, like, for example, the First Amendment movement, even the sovereign citizen movement has caused law enforcement to have to become smarter. Because if you're coming in contact with people that know more than you, well, then eventually there's going to have to be an escalation of training, escalation of knowledge, right? And we see that with all capabilities. A lot of times we see this, and people mainly want to look at this from like a firearm perspective. If you look at how far firearm training and defensive tactics of training have come, for example, since the early 90s, mixed martial arts has made that threshold significantly higher, right? The fact that, we've been fighting a war in the Middle East for over 20 years has caused tactics and training and CQB abilities to go much higher than it was in the 90s, right? So the only way we get better is when the citizens are trained and the citizens are better, and then we find that carries over into law enforcement. And so again, my desire is to make citizens as knowledgeable as possible. In fact, I'm one of the few trainers in the country, that opens up mine curriculum, my state certified curriculum, which is taught in various states because of reciprocity, but my state certified curriculum I open to the public. Most police officers, you have to verify that you're law enforcement, and they're law enforcement only, and they won't let average citizens come in and, for example, take a patrol tactics course. I open it up to everybody. The only courses that aren't open to the public are some of my ICAC, Internet Crimes Against Children, and I have a separate course for the everyday citizen. But the thought process behind that, just real quick, I do not want to teach child predators how law enforcement goes about investigations and goes about finding these individuals. Now, I think it's important we talk about it, which is why I have a course for professionals. But when it comes to law enforcement, there are certain sensitive needs as far as means and methods. And again, I'm unapologetic about going after child predators and making sure that justice is served. And going about it the best way that I physically know how to. So that's just kind of a brief initial thoughts there. Now, my biases. You have to remember, I look at case law from three perspectives. Constitutional law, I look at this stuff, these contexts, these doctrines, and these subject matters. I look at them really through three lenses. One, I look at it from a personal standpoint, right? So I'm a citizen as well. I am subject to the laws of this land like everybody else. So personally, I understand how important this stuff is. So in my personal day-to-day life, I'm researching and I'm looking at case law. I'm watching officers get deposed on the stands. I'm watching concealed carry permit holders getting deposed on the stand. I'm looking at this stuff every day. Every day I'm studying constitutional law. Every day I'm studying case law. So every single day of my life, I'm looking at this stuff from an academic standpoint, right? I'm studying this stuff, and I have to study this stuff, and I have to be able to know this stuff on a college academic level. I hold many degrees. Again, that's irrelevant, but for the purpose of understanding my bias, I hold many degrees. And I will be honest with you. Let me eat some crow here. Have I taken constitutional law classes in the past before I started my graduate level studies? I had. I've taken case law for cops courses that's put on through Blood Group. Great knowledgeable guy. A good training program. So I've taken a lot of advancing law enforcement continuing education courses. Thousands upon thousands of hours of continuing education for law enforcement. But my first real deep dive into constitutional law was not until I started my graduate level studies to get my Juris Masters. When I did that, that is when I finally got a real deep dive into constitutional law, the applications of civil law, common law. That's when I got my first real deep dive. So it wasn't until I was trying to obtain my graduate level degree did I actually get a deep dive into this stuff. And then that's when I realized how important this curriculum was to officers. Because you got to think, there's not very many officers that are going forth and getting those degrees, especially in law. So that's when I realized really how important this was and really how much I didn't know. So I'm being honest. And at that point in my police career, I had already done major crimes, executive protection. I was on a major crimes team. I had done ICAC task force, again, Internet Crimes Against Children task force. And I've already been to court at the federal level, state level, district level, obviously municipal level. So I had already went through the different hierarchies of criminal adjudication, even civil appeals, especially as it relates to children. That's a lot of times when cops get subpoenaed for civil court, custody hearings, that kind of thing. And so, again, this real deep dive didn't occur until I had already been a cop for a while, and I was obtaining this higher education. And so, again, that's another bias that we have to look at. And then, lastly, probably my biggest bias, is my professional work as a police officer. And the reason why I say that is because, unlike a lot of the keyboard warriors, I've had to go to court. I've went to court on traffic stops where I ordered people out of the vehicle pursuant to in accordance with Pennsylvania v. Mimms, Maryland versus Wilson, Brennan v. California. I've been to court on this, and I have been asked on the stand by lawyers to justify and explain why I did, and never once in my law enforcement career has a lawyer ever tried to argue the fact that their client was not seized at the time of a traffic stop. That's never happened before. And so coincidentally enough, right, I learned yesterday that my district attorney follows my channel, follows my social media accounts. And so I started asking her about this. And I even asked her, in all your experience and time as a lawyer, practicing law, doing adjudications, being in the courtroom, how many times has a lawyer, Juris Doctorate, a lawyer, somebody that studies law, how many times have they tried to argue and contend that a police officer needs reasonable articulable suspicion to order somebody out of the vehicle? And she looked at me and she just laughed. And she's like, why would a lawyer do that? Why would a lawyer argue that their client was not seized at the time of a traffic stop? 100% agree, right? So again, I have to be honest with my biases. And maybe you guys can show me a case law. And if it's out there, please let me know. I have never experienced that. The lawyers I've talked to have never experienced it. People that I look up to that have mentored me in law enforcement have never heard this. My district attorney has never heard this. I went out and I've searched high and low, contacted different law enforcement firms. Nobody has ever heard of this except for the YouTube comment section. So apparently the YouTube comment section has heard this, but people who do this in real life have never heard this or have never used this contention. And so again, I have to be honest with my biases. It's hard to grasp the idea that somebody would try to argue against all the many case laws out there that say that somebody is seized during a traffic stop. It's really hard for me to understand that concept. And that's because of my bias. Now, for those of you that have never practiced law, never have had to testify as an expert witness or even had to testify in court, I understand where sometimes this slight of the tongue, this concept sounds like it's reasonable. I understand that. But from a real application of the law standpoint, from everybody that I know that's in the industry that does this professionally, nobody can even, it's hard to even imagine that a lawyer would get up on the stand and say, my client was not seized at the time of the traffic stop. Therefore, all seizure applications of the law don't apply to my client, because even though he was on a traffic stop, my client was not seized. Officer, what was your reasonable articulable suspicion to believe that he was armed and dangerous? Again, it's just not saying that couldn't happen. Nobody I know of, neither have I, have ever experienced that or even heard that argument before. So that's my bias. I just want to be honest straight up with it. And I think that me being honest with you it's the most important way to go forward. Okay, so again, honesty and transparency there. The next thing that I want to make sure that is perfectly known, just because the court of last resort, the United States Supreme Court, just because they have affirmed a decision, does not mean that you, me, your neighbor, your dog, your mom, your dad, your teacher, does not mean your pastor, that you have to agree with it, right? It doesn't mean that you have to think that was a good decision, okay? It's kind of like you're growing up, my parents had curfews, right? Here's your curfew. I didn't have to agree with it, but I also, at the same breath and token, had to realize, well, that's the reality. And so not adhering to that standard will cause a consequence. And I think that's the biggest thing, because I'm not saying, let me just say for public record, right? For the public record, my personal opinion, not everybody that I conduct a traffic stop needs to come out of the car, nor should I order everybody out of the car just because I can. I don't believe that's a best practice. This is me being honest, right? I'm being honest and transparent, and I'm telling you my personal opinion. My personal opinion, and what I tell myself and what I train, it is not always best practice and prudent to order everybody you contact in a traffic stop out of the vehicle. It's not. It's not. I agree with all the haters on YouTube. I agree with you. Nobody's arguing that. But again, I have to live in reality. And the reality is, yes, I agree with you guys. There's no reason to do it all the time. In fact, when I've done it, it's been extremely rare compared to the number of traffic stops I've done versus the times I've needed to order people out of the vehicle. But with that being said, the reality is it can be done. And not adhering to the standards of the Supreme Court, Oklahoma law, Oklahoma Court of Appeals, 10th Circuit, whatever circuit you're in, and the Supreme Court can have repercussions. That is the reality, and that is all I'm trying to, impress upon the general public. I want you guys to be smarter. I want you guys to have this knowledge, and I agree with you. We don't have to agree with everything the Supreme Court decides on, but we also have to realize that it's the reality. So until we can accept what the reality is, there's no way we can change it. You simply saying, no, that's not right, that doesn't help anything, nor does it allow you to change, because if you don't recognize that it exists, it's not a problem. What you're doing is you're digging your head in the sand. And when you dig your head in the sand, you can't fix something. Because if you refuse to accept it, you can't fix it, right? If you know that your faucet's leaking and it's just flooding water, and you say, no, that's not happening, well, then you're never going to fix it. It's clearly pouring out. No, it's not a problem. Or if you say it's a problem for somebody else, okay, so it's never going to get fixed. And so I agree. I think things need to change. There's a lot of legislative measures out there that I don't agree with, but the only way to go forward is to fix it and address it. So with that being said, that's that portion. Let's get into the meat and potatoes, and let's really dive in and go through Pennsylvania v. Mimms. All right, so we're first going to get started by looking at Pennsylvania v. Mimms, 1977. We're going to go through it. And at the end of the day, regardless of what you think or believe, again, let me reiterate, I'm not trying to change your mind. You're going to believe what you're going to believe. I'm not here to change anybody's mind or make my point of contention everybody's point of contention. You do whatever it is you need to do. I highly recommend you get a lawyer. If you decide that you don't have to accept reality, please let me know. Give me the incident number for when you are subsequently arrested, and I would love to follow that with great interest. Okay, because again, I'm not here to change anybody's mind. I'm just here to give you the reality. So, Pennsylvania v. Mimms, 1977. Let's talk about what actually happened. We really have to understand what actually happened before we go forward. So you can see there on your screen, after police had stopped the respondent, Mimms, automobile for being operated with an expired license plate, one of the officers asked Mimms to step out of the car and produce his license and registration. As Mimms alighted, agreed, submitted to that authority, a large bulge under his jacket was noticed by the officer, who thereupon, meaning after that was noticed, then frisked him and found a loaded revolver. Mimms was then arrested and subsequently indicted for carrying a concealed weapon and unlicensed firearm. His motion to suppress the revolver was denied after a trial at which the revolver was introduced as evidence. He was convicted. Pennsylvania Supreme Court reversed on the ground that the revolver was seized in violation of the Fourth Amendment. Then the United States Supreme Court reversed the Pennsylvania Supreme Court decision and held that the frisk of Mimms, to which the firearm was found, was in fact constitutional. So let's understand why the Supreme Court did that. So as you'll see here, there's two separate thoughts. So let's talk about that. Number one, the order to get out of the car was issued after Mimms was lawfully detained, was reasonable, and thus permissible under the Fourth Amendment, period. So in this sentence, the Supreme Court's affirming the order to get out of the vehicle was issued after Mimms was lawfully detained, after he was seized. They are stating, the Supreme Court is stating, a traffic stop is not only a seizure but a detainment. Wow. And therefore, since it's a lawful, again, we're only talking about lawful traffic stops. Since it was a lawful traffic stop, it was reasonable that he was detained and seized, and thus permissible under the Fourth Amendment. Now, we're going to talk more about what a seizure is and the definitions of it as we go on. But again, here, because he was on a traffic stop, because Mimms was pulled over by the police, he was detained and seized. Therefore, ordering him out of his vehicle, controlling his movements, were permissible. Wow. Now, the states pro-offered, meaning they also, in light of, gave a justification for why this particular police officer made that order. They stated officer safety. They say that officer safety is both legitimate and weighty, and the intrusion to the respondent's personal liberty occasioned by the order being at most a mere inconvenience cannot prevail when balanced against legitimate concerns for officer safety, right? So what they're saying is the officer was justified in making the search he did once the bulge in Mimms' jacket was observed. So here in the Supreme Court case precedents, even what the officer is saying, the officer is stating, and everybody agrees with this, and even those that a keyboard warrior should agree with this, the officer did not have reasonable articulable suspicion to believe that Mimms was armed and dangerous at the time of the traffic stop. So at the time the officer put his lights on and detained him, the officer did not have reasonable articulable suspicion to believe that Mimms was armed and dangerous at the time of the traffic stop. The only time the officer had reasonable articulable suspicion that Mimms was armed and dangerous was after he exited the vehicle and a large bulge was observed by the officer in his jacket. Let that sink in for a second. The officer did not have reasonable articulable suspicion that Mimms was armed and dangerous until after he was ordered out of the vehicle. Then, once he was out of the vehicle, that is when the bulge was observed, and at that time, he had reasonable articulable suspicion to believe he was armed and dangerous. So how do you make that work, right? How do you make that work? How do you make it work if you believe that you need reasonable articulable suspicion to order somebody out of the vehicle, when clearly the officer did not have reasonable articulable suspicion to order him out of the vehicle? Nor did he need to, because again, the United States Supreme Court held that he was lawfully detained already. The fact that he was lawfully detained is what gives the police officer the ability to control a subject's movement. That's all it is, as long as that movement is reasonable. And the Supreme Court says it's reasonable to order somebody out of a vehicle on a traffic stop. Because again, at the moment of seizure is at the time of the traffic stop. And again, it is both the intrusion into a respondent's personal liberty occasioned by the order, being at most a mere inconvenience, cannot prevail when balancing against legitimate concerns for officer safety. Again, this idea that the officer has to have reasonable articulable suspicion that he's armed and dangerous in order to order him out of the vehicle is nonsense. If we look at the Supreme Court case hearing, the officer did not have reasonable articulable suspicion that he was armed and dangerous before he ordered him out. And if anybody disagrees with me, please tell me what the officer was thinking. Please tell me why this officer lied on the stand. Why would he lie about not having reasonable articulable suspicion before he ordered him out of the vehicle? Make it make sense. So let's talk more about seizures. So what is a seizure? Let's talk about seizures. Let's talk about how the Supreme Court case has expounded upon this since that initial Pennsylvania v. Mimms 1977. So let's go further with it. As you can see here on your screen, we have Maryland v. Wilson, 1997, ordering the passenger out of a vehicle. Okay, the Supreme Court again has affirmed that an officer making a traffic stop may order passengers to get out of the car pending the completion of the stop. The Supreme Court further affirmed that this is a practical matter. Passengers are already stopped by virtue of the stop of the vehicle, so the additional intrusion upon them is minimal. Now, why is this important? If we look at Maryland versus Wilson, the officer did not order the passenger out of the vehicle for officer safety, of him being concerned about the passenger being armed and dangerous. That's not why he ordered him out of the vehicle. If you look at the case law precedent, it's clear this trooper was a trooper. He suspected there was some kind of drug activity going on. There was some dope stuff. So it makes sense that he would want to, and we'll talk about this in another video. I really want to get into the drug interdiction stuff because there's a lot of case law on that people just don't understand. And so again, I just want to present that in a way that at least you now know why. But I digress. So the trooper in Maryland v. Wilson was thinking that there's something going on with dope, so it's a common maneuver. Hey, go ahead and step out for me. He's giving him an order to step out of the vehicle. When he steps out, dope is found. He makes the hook. So the trooper here was not asking him out of the vehicle because he was scared of the passenger being armed and was going to hurt him. He did it because he's looking for dope. So even in this case, how do you argue if the trooper had reasonable articulable suspicion? What reasonable articulable suspicion in this case was even mentioned of the individual being armed and dangerous? I'll wait forever because it's not there. Again, the trooper ordered him out. Dope fell. Wow, now we're automatically in Chamel v. California incident to arrest situation, right? That's plain view. Harris v. United States, 1983. So we're already in plain view doctrine at that point. So again, ordering the passenger out of the vehicle, 100% permissible by the Supreme Court. United States Supreme Court said yes, absolutely 110% permissible because for practical purposes, passenger is seized. The seizure is what, again, allows the officer to make reasonable requests to control movement. What would be another example? I'll hold that thought. We need to talk about one more case law first. What is a seizure? 2021, the Supreme Court defined what a seizure is. The United States Supreme Court holds that the application of physical force to the body of a person with intent to restrain is a seizure. To restrain is a seizure, even if the person does not submit and is not subdued. Torres v. Madrid, 2021. So here the Supreme Court says, again, the application of physical force to the body of a person with intent to restrain is a seizure, even if the person does not submit and is not subdued. So people ask, well, what allows a police officer to control my movements? Well, if he can apply physical force to your body to move you somewhere, the Supreme Court says that that's permissible, as long as it's reasonable. Again, the Supreme Court says it's reasonable to ask you out of the vehicle. It's reasonable for the officer to take physical custody of you. Physical force to the body. So if I tell you, hey, I need you to move from point A to point B, you're on a traffic stop, pursuant to in accordance with probable cause or reasonable articulable suspicion as defined by United States v. Cortez, I need you to exit the vehicle. I need you to go from point A to point B. There's a couple ways that can happen. I can ask you and say, hey, can you do this for me, please? I'm giving you a direct order, but I'm trying to be nice. Can you do it? Okay, cool, right? Because as we know from the officer use of force matrix, presence, verbal commands is a physical use of force. A lot of people don't know that, but just an officer being in uniform, displaying a badge, having a gun, that is considered a level 1 force by the Supreme Court, by the Department of Justice, right? So your application of force comes with a police officer simply being a police officer. Then verbal commands, then soft control, hard control, open-handed techniques, intermediate weapons, deadly use of force. There's a matrix, right? So asking, giving a directive is a use of force. They can do it on their own, or if you're seizing them, you can physically do it. And again, the United States Supreme Court says that's reasonable. But at the end of the day, if you're ever confused about what is reasonable, not reasonable, you can have your opinions, the officer can have their opinions, and that's going to be demonstrated in court. So if your idea is, well, I'm here for speed, the officer has no reason to pull me out of the vehicle because I'm not armed and dangerous. I know I'm not armed and dangerous. Therefore, this is unlawful stop. And this is an unlawful a violation of my Fourth Amendment. You can believe that. I don't want to take your beliefs away. All I'm saying is let's not be surprised. Let's not be surprised. One more time. Let's not be surprised if you get a young rookie trooper that knows Pennsylvania v. Mimms, because troopers go over Pennsylvania v. Mimms with extreme intensity. Do not be surprised if that young rookie trooper orders you out of the vehicle, you say no, then he applies a Torres v. Madrid 2021 physical use of force of application to the body to seize you and put you in point A to point B. And then don't be surprised if you hire an attorney and you tell your attorney he didn't have reasonable articulable suspicion to believe that I'm armed, and your attorney says, you expect me to go in front of a court of judges and my peers and argue that you weren't seized. Don't expect them to say, I'm not doing that. That's all I'm saying. Believe whatever you want. You know what I mean? Believe whatever you want. I just don't want you to be surprised when you get to that point that an attorney refuses or doesn't want to provide the argument that you were not seized on a traffic stop. Just clarification there. I just don't want you to be surprised. Okay? And again, you're right. The courts will decide what is reasonable, but an officer applying the least, like I said in my last video, the least intrusive the least intrusive use of force to accomplish his goal. I just don't want you to be surprised. Like, all right. So if he uses force because you are disobeying a lawful order, just again, don't be surprised. So with that being said, let's talk about some other common sense applications in which this could apply, right? An officer responding to a disturbance call, right? Disturbance. What does that even mean, right? It's a good point. So hypothetically, if an officer responds to a disturbance call and somebody says, hey, a man and a woman, they're married, they're arguing, and they're yelling at each other, and they're on private property or whatever, they're in the front yard yelling at each other, cool. Officer shows up. He may have reasonable articulable suspicion that there is a crime at foot, right? Whether that's disorderly conduct or whatever. He has reasonable articulable suspicion. Not probable cause, reasonable articulable suspicion, right? So he has observable conditions, objective facts to conclude that a crime is afoot. Reasonable articulable suspicion. So a police officer shows up at a disturbance call. Man and woman are there. They show up. They're clearly upset. They're heated. Officer seizes both individuals and detains them. Officer tells the husband, come here. Other officer tells wife, come here. What do you think is going to happen if that gentleman says, no, I don't want to be separated from my wife. I need to talk to her. This happens every single day in law enforcement. Does the officer have a right and ability to separate the parties for investigative purposes? Separate the parties to talk to them? Does he have that right? You can say no. This is common practice as every day. So if he were to try to pull away from the officer while he's lawfully detained, I expect that officer, pursuant to in accordance with Torres v. Madrid 2021, to use physical force, reasonable physical force, pursuant to policy, pursuant to the use of force as established by Connor v. Graham, right? I expect him to use reasonable, or her to use reasonable force, and they will keep those parties separated. Now, they can go back and they can argue that that force was unacceptable and unreasonable. But you know what the lawyer's not going to argue? The lawyer's not going to argue that his client was not seized at that time. You know what I mean? Your lawyer's not going to argue, well, my client was not seized. Make it make sense? No, they're going to argue my client was seized, right? But the use of force was unreasonable for X, Y, and Z. And so if we're saying in a traffic stop the use of force was unreasonable, and that unreasonable use of force was ordering somebody out of the vehicle, good luck. All right. Let's talk about a few other contentions from an academic prowess standpoint. I'm also glad I'm doing this video today because I have an individual, Andrew-CS12D. So Andrew-Charles Sam 1 Tom David has been responding. He's very upset with my video. He's made it very clear he's upset with this concept. He believes that ordering somebody out of a vehicle without reasonable articulable suspicion is a crime in violation of the Fourth Amendment. He is essentially saying that by an officer doing that, they are, if it's unlawful, then I'm kidnapping you. And that officers should be held accountable. I mean, there's no way you can say that I unlawfully detained you without saying that I kidnapped you. Really, if it's an unlawful detainment, then I'm holding you against your will and I'm kidnapping you. So I obviously take those concerns very seriously. You can see his statement here on the screen there. I told him and I made sure that this would be addressed. So I'm going to do this individually because this has been my this contention has been the loudest in the video. And so he has a very simple question. We kind of already talked about it, but again, I'm doing this live. So what law or case law gives officers the authority to control someone's every minute movement while they are seized or detained? Again, so there's two that come to mind immediately, and we'll kind of flesh this out. We'll kind of flesh this out more. But I think the biggest thing is this question, number one, is being asked in bad faith. And number two, let's be honest. I'm not saying as a police officer, I'm trying to control everything you do, right? If I tell you to stand there and then you start doing this, I'm not saying that that is against the law, nor am I saying that I'm going to stop you from doing that. Or if you say, you're sitting there and I'm like, oh, I'm standing right here, but I'm going to put my foot to the right, I'm going to put my foot to the left, I'm going to put my foot to the right, I'm going to put my foot to the left. Am I saying that I'm going to put you in a hobble then? No, that wouldn't be reasonable. What I'm saying is I have the ability to control movement as long as it's reasonable and I can justify it. So the Supreme Court has said that you're seized. So all I'm doing is I'm saying, hey, I need you to step out of the vehicle. You're going from point A to point B, and that's justifiable because you are in fact seized. You're not free to go. So the question would be for you, well, if your movements are not being controlled, why don't people just jump in their car and continue to drive? Why don't they do that if they're not seized? If you're truly not seized and you truly have freedom of movement, why don't you just get in your car and drive away? Or why don't you just why don't drivers just get out of the vehicle and just walk away? Under that ideal, an officer would have no authority if you got out of the vehicle and walked away to stop you. Again, that's so nonsense that nobody's taking that seriously. Again, I'm not saying that I'm going to control every single movement, but it's absolutely reasonable as you're seized that your movement is going to be regulated. And again, Torres v. Madrid says the physical application of force. So I'm using physical force to control your movements as long as it's reasonable. And ordering you out of the vehicle is reasonable. We're going to talk about some other academic stuff here in a second. But again, this came in live, right? Another one that's really good is failure to train case law. Harris v. Canton. And so Ohio case. Harris v. Canton, or Canton v. Harris. In this case, a woman was lawfully seized, lawfully detained, and she is requesting medical, right? She's requesting medical. The officers say, no, we're not going to give you medical. Well, if she wasn't seized, why didn't she just go get medical herself? Because the officers were controlling her, right? The officers were saying, no, you're not free to go. You're seized. You're detained, which ultimately resulted in an arrest. Well, guess what? She asked for medical. Medical never came. She filed an emotional damages lawsuit, and she won. Again, Canton v. Harris, or Harris v. Canton, 1989, Ohio case. And so in this case, it's clear the officers had control of her movements, had control of even having medical respond to her, she had no control over her bodily autonomy. And the Supreme Court said, you should have known better, police officers. That is wrong. We're hitting you with a lawsuit for failure to train. Because you should have known if somebody was requesting medical, you provide them with medical. And we're seeing this with mental health stuff. We're seeing this all over. So yes, officers obviously do have control over who can access people seized and detained in their custody. And they can absolutely control, even if it's temporarily, not only the access people have to them, but their movements to some degree. That's all I'm saying. I'm not saying that if you want to sit there and move your face around and do this, that the officer's going to hold your face and say stop. No, that wouldn't be reasonable. Nobody's advocating for that, Mr. Andrew. What we're simply stating is when you're seized, an officer, according again to Torres v. Madrid, may enact physical force to control your movements temporarily as long as it's reasonable. And the Supreme Court has said ordering you out of the vehicle is reasonable. That's all we're talking about. I'm not asking you to play Simon Says on the side of the road, nor would I ever advocate for that, because it wouldn't be reasonable. If you're there for a traffic stop, we need to address the traffic stop and get you on your way. So playing Simon Says would be what's called prolonging the traffic stop. And again, we're going to go all into that. And I promise you, again, I'm here to be transparent and honest, but Mr. Andrew, if you think that that's unreasonable, I completely get it. I want you to be your best person. And at the end of the day, if you believe that since you're speeding, the officer doesn't have the authority to order you out of the vehicle, do that. I know you won't, right? I know you're being a keyboard warrior. I know you're really not going to do that. I know you're really not going to follow the things that you're advocating online. But if you do, let us know. Again, I will follow your case with great interest. Now let's talk about this again. Like I said, let's get to the academic prowess standpoint. So from an academic standpoint, again, don't take my word for anything at all. Believe your lying eyes. So I encourage those of you, Andrew, this is one for you. I encourage you just to go out and Google this stuff, right? Go to associated law firms. A lot of them have this content, especially as it relates to Pennsylvania v. Mimms and Maryland versus Wilson, on their website. So this comes from Marsh Associates. Okay, they are a legal law firm. They are an expensive legal law firm, and they actually have an article on this. So let's read what the lawyers are saying. Because again, don't listen to the police instructor and trainer. Don't listen to me. Don't listen to what the lawyers are telling you. Again, pretend my opinions are relevant. If you're this far and you don't agree, they're already irrelevant. So argue with the lawyers. The lawyers state you can refuse to exit your vehicle if ordered by police. Can you refuse to exit your vehicle if ordered by police? If a police officer lawfully orders you to exit your vehicle during a traffic stop, you are required by law to comply. Again, this is not me. This is Marsh Associates. An officer's ability to order a driver out of their vehicle is supported by the Supreme Court rulings in Pennsylvania v. Mimms 1977 and Maryland v. Wilson 1997. In the Mimms case, the court ruled that police officers can instruct drivers to exit their vehicles during a traffic stop without needing additional probable cause or reasonable suspicion. Again, without needing additional probable cause or reasonable suspicion. This authority was expanded in Wilson to passengers. It is important to understand that an officer does not need probable cause or reasonable suspicion of another crime to issue this order. Additionally, officers can instruct vehicle occupants to re-enter the vehicle. Now, this brings up a really good point. So this isn't me, okay? Again, this is not Solution-Based Law Enforcement Services. This is not SB Leo 911 saying this. This is not me saying this. This is a law firm saying this, okay? This is not me. Again, I'm not saying this, Andrew. I am not saying this. The lawyers are saying this, okay? Andrew, what are the lawyers saying, bud? The lawyers are saying that an officer can order you out of the vehicle on a lawful traffic stop without needing additional probable cause or reasonable suspicion. Now, if they want to perform a Terry frisk, then yes, they would need reasonable articulable suspicion that you are armed and dangerous, pursuant to in accordance with Terry v. Ohio and also Pennsylvania v. Mimms. But just to order you out of the vehicle, they don't. And so, do I have to frisk everybody out of the vehicle? No, Andrew. No, Andrew, I don't. Right? So again, this is Marsh Associates, and they're making a really good point. And here's another point. If I were to, Andrew, hypothetically, right? If I were to drive, you're doing a traffic stop and you were speeding, because you brought up speeding in the comment section. If you were speeding and I were to stop you and you were to get out of the vehicle, if I don't have reasonable articulable suspicion that you're armed and dangerous, can I order you to go back in the vehicle? According to your logic, I would be unable to give you a lawful order to re-enter your vehicle. Because just because you get out of a car on a traffic stop, even though you're seized, in your opinion, if I don't have reasonable articulable suspicion to believe that you are armed and dangerous, according to your logic, I wouldn't be able to order you back in the vehicle. But Andrew, we know that's not true. And again, this isn't me saying this. This is Marsh Associates law firm. So lawyers, Andrew, are telling you. Lawyers are telling you this now. And all the people that are skeptical, the lawyers are saying that no, actually on a lawful traffic stop, they don't need any additional reasonable articulable suspicion or probable cause. Again, believe your lying eye. Don't believe your lying eyes, right? Now let's look at another one. This comes straight, as you can see on your screen here, from the U.S. Department of Justice. This is a FBI Bulletin Memorandum of Understanding, Volume 66, Issue 6, June 1997. It's 6 pages long. The author is L.A. Regina, and this is talking about extending the Mimms rule to include passengers. So let's read the abstract, because it's 6 pages. It's a great read. Andrew, I encourage you. It's here. The numbers are here. It's a great read. In giving law enforcement officers the automatic authority to order all occupants from a lawfully stopped vehicle, again, lawfully stopped, the Supreme Court concluded that such a slight restraint on an individual's freedom of movement is permissible under the Constitution when balanced against concerns for officer safety. This article also discussed prolonged detention or limited search for the purpose of detecting the presence of weapons. Both require more justification than the mere occurrence of a lawful traffic stop. Again, this is reaffirming, yes, automatically on a traffic stop, the police can order all occupants out. But in order to prolong the detention or conduct a limited search for the purpose of weapons, you need what's called reasonable articulable suspicion. Again, that is affirmed by Pennsylvania v. Mimms. It is affirmed by United States v. Rodriguez for talking about, prolonging the stop. So I cannot prolong the stop to order you out of the vehicle, right? And I can't just touch you and frisk you for weapons, because in order to frisk, you have to touch without reasonable articulable suspicion. But absolutely, just based upon the fact that this is a traffic stop, I can't order you out of the vehicle. Again, Andrew, FBI Law Enforcement Bulletin. There's a whole article written on this. NCJ number 168679. And again, Marsh Law Associates. Again, the lawyers are saying this. The federal government is saying this. The FBI is saying this. This is not me. This is not me saying this. I didn't write that article. I'm not affiliated with Marsh Law Associates, right? I'm not. Now let's look at another. Let's look at another one. Let's go to one further. So I have another criminal defense attorney in Sioux Falls, South Dakota, Edward Engel, right? And so, again, he has a law firm. And so what this person does is I think it's great, he allows people, the general public, to ask him questions, and then he answers them. And he does this as part of his campaign to advertise. It looks like he has virtually a five-star response here. And again, everything's on the screen here. And so this is the question that's coined to him. Okay. Can a police officer make you sit in the passenger seat of his vehicle while he writes you a ticket? Again, this has nothing to do with me. I am not criminal defense attorney in Sioux Falls, South Dakota, Edward Engel, licensed for 14 years. I am not this guy. Okay. So again, Andrew, this is a lawyer saying it. It's not me. All right. This is the lawyer. Again, Andrew, I'm just reading just like you can. I'm just reading. So, a routine traffic stop on a highway. I was speeding, 75 in a 65 zone. I had my 2 sons in the car with me. Officer told me to get out of the vehicle, which I did, and then told me to sit in the passenger seat of his vehicle while he wrote my ticket. I didn't shut the door or put my legs in. He told me to shut the door because I just halfway did. I kept 1 foot on the ground the entire time. Is it legal for him to have me sit in his car? I was very uncomfortable as a single woman out in the middle of nowhere, South Dakota. I told him I was very uncomfortable, and he just smirked. So again, Andrew, this perfectly articulates your point, right? Officer gave her a command. He is controlling movement, but she is now asserting some authority over her sovereign body. So he says, shut the door. You know what she did? She halfway shut the door and she kept a foot out. Oh, wow. She's asserting her rights, Andrew. You should be proud of her, Andrew. She is asserting her rights. And again, I think that at the end of the day, as a police officer, again, do I make normal procedure of ordering people out of their car into my car? There are circumstances which that's a good idea to do, and there's some circumstances which it's not. Different video for a different day. But at the end of the day, that's very common amongst troopers. That is very common. Troopers get specialized training in that. In Trooper Academy, I know for the Oklahoma Highway Patrol, they have a whole block of instruction on Pennsylvania v. Mimms and conducting traffic stops and bringing the driver or an occupant back into the passenger side of their vehicle. Again, they're trained in this. They fight in this, right? So they have tons of scenarios where that person then fights them. So in their car is their environment. And so when you have control over your environment, it says a lot when it comes from an investigation standpoint, evidence collection, and even the fact that you're owning and controlling the scene because it is your vehicle. So now you're bringing somebody into your element. Don't want to get too far down the weeds with this, but amongst highway patrolmen, amongst state troopers, this is a very common practice, Andrew. So we have to ask, Andrew, we have to ask ourselves, is this permissible? Well, I'm not going to answer the question, Andrew. I'm going to have Edward Engel, a criminal defense attorney in Sioux Falls, South Dakota. He's going to answer the question, Andrew. I'm not going to answer the question. Yes, the officer is allowed to have you sit alone in the patrol vehicle with him or her, especially if the officer perceives you as either a flight risk or potential threat to his safety or her safety. And even if he or she didn't, it's still considered reasonable for an officer to ask you back in his or her vehicle while they continue to investigate and or write you a ticket or give you a warning. This assumes, of course, the officer is justified in stopping you in the first place. So again, Andrew, I'm going to read this again for you. I know you can read, but I'm going to read it again for you. Especially if the officer perceived you as either a flight risk or potential threat to his or her safety, and even if he or she didn't, it is still considered reasonable for the officer to ask you back to his or her vehicle while they conduct an investigation or write a ticket or a warning. Let me say it one more time. And even if the police officer does not view you as a potential threat or for safety, they may ask you back to his or her vehicle while they conduct the investigation and or write you a ticket or give you a warning. Andrew, I'm quoting here. I'm not saying this, Andrew. I'm not saying this. A criminal defense attorney in Sioux Falls is saying this. And again, this just reiterates the idea that what criminal defense attorney, what attorney, and if you're an attorney out there and you were going to argue and you think there's a good argument for a traffic stop not being a detention of the occupants of the vehicle, please tell me. Please let me know. Please correct me. But again, it's clear as day that the people who practice law all over the country, they have all came to the same conclusion. The consensus among the professionals in the industry all seem to be saying the same thing, Andrew. They all seem to be saying the same thing. I have to say one thing, though. Let me just say, it seems like I'm giving Andrew a hard time. I'm not. I think he's asking the great questions. And here's the thing: what Andrew doesn't realize, or maybe he realizes now, it's clear he's very intelligent. I don't want to assume this person is a very intelligent person, and I think that's great. And let's be honest, this is helping the public. Andrew is performing a service here that is helping people in a way that is going to far supersede even him, and I truly believe that. And I want to thank him, or I want to thank this person. Whoever's holding the moniker Andrew and that you've seen the screenshot, I want to thank him. We should all thank that person. Sorry, I'm living here in the South. The gender language is not really my forte. But this person, and I do apologize for that, but this person is doing a great service to their community, to the nation. This is important because we do need to talk about this. We do need transparency in this. And so it may seem like I'm giving this person who holds the moniker Andrew a hard time. I'm not. I think this is important. I think this is needed. And I appreciate the fact that they're doing it. And ultimately, we all have to learn and we all have to be better. And I think this is a super important concept that people really, truly need to understand. And again, this isn't just me saying this. I'm not getting this just for me. I'm getting it because there is a general consensus among people in criminal justice and people that operate in this field of what I'm saying. And that's what I'm trying to present. I'm trying to present the reality. And I do appreciate Andrew for bringing this to light. And I think this is a great learning tool. And I hope that people look at this and they gain information from it. And I really appreciate Andrew going out on a limb here and doing this for the betterment of everybody. And I do, in all regards, Andrew, I do appreciate you. Thank you. So let's talk about another myth, okay? And the myth is it's always safer for law enforcement to keep people in their vehicles, right? Now, I can give you a ton of different academic peer-reviewed research on this. I can give you all sorts of stuff. I can say based upon my training experience. I'm not going to do that. Instead of me sitting here just telling you why, let me show you.
You want to call it a reckless or DUI if they take off?
He's been swerving.
Yep. There we go, PA. Move your hand real quick.
Oh, stop.
Go! Shots fired. Officer needs help. Get the car!
What was that? You good?
Go! Just go! We're going to be northbound. Northbound Broadway from Rosecrans.
They hit us with, dude.
Hey! No, go.
We are now seeing the exact moment a driver slammed into a state trooper. New dashcam video was released today. Trooper Russell Calicote was parked on the side of a Tulsa interstate in mid-April. Watch this. Suddenly, a 19-year-old woman slammed into his car. She was ticketed for driving distracted. Trooper Calicote is recovering at home right now. Now, listen to this. The Highway Patrol says Trooper Calicote was hit in almost the exact same spot 10 years earlier.
Wow.
Now, I would be remiss if we didn't end this conversation with talking about other applicable considerations that you may not have considered. And again, I'm doing this because I honestly want to have the utmost transparency. And I believe I've accomplished that. I've told you what my biases are. I've 100% explained it. I've been up and honest to the forefront. I've been honest about my biases. I've been honest about my perspectives and where I come from and the why. And truly, I'm not doing this to better law enforcement. I'm doing this to better the citizens. And when the citizens are enriched and when they're better, law enforcement is better. The best way to improve law enforcement, I believe at this time, is to improve the citizenry's knowledge, to give the citizens as much training as possible. And I want to give law enforcement the world. I want to give them all the training. But there's so many roadblocks in the way for officer training at this point that as one person, I believe my resources are best invested right now in educating the public. Honestly. And again, I may lose my job for that. And that's fine. And I've accepted the fact that I could very well lose my job for saying that I want to enrich the knowledge of the general public. And that's okay. That is something that I have accepted and I'm willing to take on. But at the end of the day, we have to at least come to some baseline understanding that I agree. There may be precedences we don't agree with, but we have to accept that they're the reality. And until we're willing to do that, again, we're going to continuously be ineffective. So let's talk about some other considerations. So again, I'm talking about the state of Oklahoma since I'm here, but I'm sure there's other places where this is absolutely applicable. So let's look at 11 Oklahoma Statute 28 TAC 114.1. Arrest for misdemeanor traffic violation other than parking or standing, right? So the reason why I'm even mentioning this is because this is a whole Oklahoma statute that's dedicated to explaining procedures for releasing somebody on their own recognizances on a municipal misdemeanor traffic violation. Now, I say that because my question to you is, do you know what every traffic violation in your state is? Do you? Do you know what every misdemeanor traffic violation or moving violation in your state is? Because if you don't, could you inadvertently be putting yourself in a bad spot when the officer, and I'm not saying it's right, I have to bring you the reality, right? An officer is stopping you, and let's say it is for a misdemeanor violation. Do you think he's going to walk up there and necessarily say, hey, I stopped you for a misdemeanor traffic violation? He may not give you that information. He just may say, I stopped you for X, Y, and Z. He may not explain to you where it falls on the criminality scale. And if he orders you out of the vehicle and you're like, no, I'm not doing it, we're no longer in a Pennsylvania v. Mimms area at all. You may inadvertently unbeknownst to you, you may already be in a lawful arrest custody situation to where now your whole entire vehicle can not only be searched pursuant to a tow policy and based upon tow, but your person's going to be searched because pursuant to in accordance with Chamel v. California, you have Illinois v. Ross, Illinois versus Lafayette, all these Supreme Court case precedences, they're going to go way beyond just ordering you out of the vehicle. Again, this is obviously not a Pennsylvania v. Mimms situation if you've committed a misdemeanor crime and not even known it. But again, those are considerations, because if you don't know every misdemeanor crime that's in your state, man, you can really hem yourself up. Something that would have been probably a hefty ticket is now going to result in you in handcuffs and being lodged at your county jail. I'm not saying I agree with it, folks. Again, I'm not saying I'm agreeing with it. But what I'm saying is this is the reality of how things shift. Your ignorance of the law will not override the fact that a police officer is going to say, you know what, this person's not cooperating with me. I was going to give them this $300 or whatever dollar ticket. I was going to give them this X, Y, and Z cost ticket. But since they don't want to be cordial with me, they don't want to be respectful, which you're not required to. But since they don't want to work with me, I'm going to use my discretion and we're just going to go ahead and arrest on the municipal misdemeanor. Why put yourself in that situation? You can answer that. I can answer that. Please tell me in the comment section why you would put yourself in that situation. And if it's for principle of the matter, great. If you do that, let me know. I'll follow the incident number with great interest, like I said before. So those are considerations. Tow policies are considered, are going to be, considerations. I'm putting stuff up here on the screen, but there are a lot of different reasons why a police officer may, for example, tow your vehicle based upon state statute. You may not know that. You may not know that what you just committed was an offense in which your vehicle can be towed, especially in the state of Oklahoma for registration. As you can see, the registration act's up there. That is a towable offense. So in order to tow the vehicle, they're going to order you out of the vehicle. And if you want to not do that, well, again, like I said in my last video, I'm not going to go over all of it because this video is long enough. But then expect the state to start to levy these obstruction charges and stuff. And I did a really good breakdown in my last video. So please, I'm going to link that video in the comment section, in the description box below for you to look at. But these are all things that I want you to consider. And these are all things that I think are important for you to consider. So again, regardless of how you look at this now, and again, I'm not here to change your mind. Regardless of how you look at this now, regardless, all I can hope to impress upon you is what the reality is, and there are ways to change this. And if you feel like that is a worthwhile human endeavor, let me know. Keep me updated. Again, I don't have any skin in the game. The citizens get to choose what their human endeavors are, and they get to choose how they wish to go about it. And that is none of my business. Again, I'm not saying I agree with every single court decision put out by the United States Supreme Court. I'm not saying that. But what I do have the common sense to say is I can say I don't agree with that decision, but I sure understand that it is the reality law of the land because the United States Supreme Court is the court of last resort. I can absolutely admit that and understand that. I'm a person of color, right? There was a time in this country where somebody like myself did not have rights. Could I disagree with the idea and belief that slavery was once allowed in this country? Do I have to agree with that? Before 1979, there was no Supreme Court case precedences that allowed the marriage on a federal level in Lovings versus Virginia, 1979. Can I admit that? Yeah. Because as somebody who's married to a person of that's a different race than me, if I was in the state of Virginia, that would be an arrestable crime. Now, with that being said, I can disagree with it. Absolutely, I disagree with that. But at the same time, the only way to change it is to acknowledge that it exists, to acknowledge that I don't agree with it, and to set forth change. And I'm so glad, and let me say this from the bottom of my heart, I am so glad that there were citizens, God-fearing citizens that stood up, citizens that weren't religious affiliated, just citizens in general, that citizens stood up and said, slavery is wrong. that citizens stood up and say discrimination is wrong, the fact that citizens stood up and say the right for somebody to have freedom of speech, the right for somebody to marry who they want to marry, that should be something that should be enacted at the highest level. And I'm glad those people didn't do what the people in the YouTube comment section do. I'm glad they didn't put their head in the sand and say, well, it's not real. I'm glad they acknowledge that it's real, and I'm glad that they made changes, because truly I'm sitting on the shoulders of giants. And I could not be more happy for their vigor. I could not be more happy for their 110% commitment to the change and benefits that allow us the rights and freedoms that we have. And I'm not saying, and let's be honest, I say that meaning that I agree there's more that needs to be done. But I am truly sitting on the shoulders of giants, because there's people that put everything on the line. And the reason why they did that, and the reason why they were successful, is because they weren't just arguing in the comment section. They realized the reality, and they set forth that change. And they made what they envisioned reality should be, they made it a real application. They made those changes. And I couldn't be more honored to be an American. I couldn't be more honored to the fact that people that didn't look like me put it all on the line to give us the values and to give us the changes that they have. Again, 100% humbled. And again, arguing with me in the comment section is not going to make those changes. We sit and we enjoy the luxuries we do because giants before us realized what the reality was, and they set forth change. With that being said, thank you for watching, and as always, guys, long live the Republic.